It's great to see that so many states are legalizing weed so quickly. When legalization is on the ballot, it wins far more often than it loses. It's even winning in places where it has previously lost, like in California. However, a dark cloud that hovers over these states is the federal government. The feds have full authority to destroy the recreational and also the medical marijuana industries whenever it pleases. In 2005, the Supreme Court decided in the case of Gonzalez v. Reich that the federal government has every right to criminalize growing marijuana, even on one's own property for one's own use, and even in places where it is legal at the state level. This is one of the ugliest Supreme Court rulings in recent history. Ruth Bader Ginsburg ruled in favor of the constitutionality of federal meddling in one's own personal weed stash, and this is one of the few cases in which Clarence Thomas and William Rehnquist were voices of reason. The defendant, Angel Reich, grew her own weed on her own property for her own medical use. She lived in California, and California state law allows this. Her doctor even testified on her behalf that marijuana was medically necessary and that she could possibly die without it. The court, however, ruled that the federal government has the constitutional authority to take away her weed because of the clause in the Constitution that allows it to regulate commerce between the states. Now, the questions that immediately pop into the heads of most reasonable people who hear this are, how does this count as regulating interstate commerce when Reich wasn't selling the weed across state lines? And how does it count as regulating any kind of commerce if someone is not growing the weed for commercial purposes? The justification is based on an earlier decision, Wickard v. Filburn, which ruled that federal regulations on how much wheat farmers could grow were constitutional because of the effect that growing wheat had on national market prices. It affects supply and demand. Similarly, the court argued, the parallel concern, making it appropriate to include marijuana grown for home consumption in the Controlled Substances Act, is the likelihood that the high demand in the interstate market will draw such marijuana into that market. While the diversion of homegrown wheat tended to frustrate the federal interest in stabilizing prices by regulating the volume of commercial transactions in the interstate market, the diversion of homegrown marijuana tends to frustrate the federal interest in eliminating commercial transactions in the interstate market in their entirety. What's scary about this reasoning, however, is that if effects on the interstate market for a good or service were a reasonable basis for meddling with commerce that occurs within a state, then it is hard to see where you can draw the line between regulation of interstate commerce and regulation of intrastate commerce. Moreover, such an interpretation grants the federal government not just the power to meddle in intrastate commerce, but also in non-commercial activity like growing your own weed for your own use. Here are some quotes from Clarence Thomas's dissenting opinion. Respondents Diane Monson and Angel Reich use marijuana that has never been bought or sold, that has never crossed state lines, and that has had no demonstrable effect on the national market for marijuana. If Congress can regulate this under the Commerce Clause, then it can regulate virtually anything, and the federal government is no longer one of limited and enumerated powers. Respondents' local cultivation and consumption of marijuana is not commerce among the several states. If the federal government can regulate growing a half-dozen cannabis plants for personal consumption, not because it is interstate commerce, but because it is inextricably bound up with interstate commerce, then Congress's Article 1 powers, as expanded by the Necessary and Proper Clause, have no meaningful limits. Whether Congress aims at the possession of drugs, guns, or any number of other items, it may continue to appropriate state police powers under the guise of regulating commerce. The legal recreational marijuana industry has so far been allowed to exist at the whim of the Obama administration. This court decision gives the feds the authority to put a stop to it at any time they like. Will the Trump administration continue to permit it? It looks like Trump plans to appoint Jeff Sessions to the office of Attorney General. In the past, Sessions has said, we need grown-ups in Washington to say marijuana is not the kind of thing that ought to be legalized. It ought not to be minimized. That it is in fact a very real danger. And good people don't smoke marijuana. It looks like legal weed in the United States is in significant danger.